There are two certain facts in life. Life begins with the heartbeat, and life ends with the heartbeat. This is the simple fact of life. But lately, assisted suicide remains a hot and debatable topic. In the past, nobody had the option of terming their own life. Here in the United States, it wasn't until 1997. Today, physician-assisted suicide is legal in 10 U.S. states and the District of Columbia. There are 9 states mandated by law. There are 9 states mandated by state law: Colorado, District of Columbia, Hawaii, Maine, New Jersey, New Mexico, Oregon, Vermont, Washington, and there are 2 states that are mandated by court ruling, which is Montana and California. The specific method in each state varies, but mainly involves a prescription for a licensed physician approved by the state in which the patient resides. Many proponents of the practice now refer to the term as physician-assisted death, PAD, and no longer include the word suicide when they're describing the act. As of October 2022, it is legal in 10 countries aside from the United States: Switzerland, Netherlands, Belgium, Luxembourg, Colombia, Canada, and the newcomers that have established in 2021: Austria, Australia, New Zealand, and Spain. Physician-assisted suicide differs from euthanasia, which is defined as the act of assisting people with death in order to end their suffering, but without the backup of controlling legal authorities. Since 1997, there have been many laws that have passed throughout the years. Bills like the End of Life Bill have divided our country. The impact of the bill has many perspectives. One of the perspectives is that dying is not the actual choice that the person is making, but it's the choice of not to suffer. They do choose life, but not the action of pain and suffering. Suffering and pain for the body, for their own body, and for the families as well. The quality of life. A physician's perspective is that a physician's duty is to avoid causing physical and moral health to patients, and it is embodied in their Hippocratic Oath. In the Hippocratic Oath, it includes the commitment that states, "I will not give a drug to anyone if I am asked, nor will I advise such a plan." Doctors feel that now that the government is involved, they will be forced to break their vows. This has caused many doctors to stop practicing or move away from the states that have the laws in place. A phrase that always comes to mind to physicians is, "First, do no harm." Physicians have been an important part of society, and society has depended on physicians for over 2,500 years. And they don't feel right with the government giving them specific laws that they feel that breaks their oath and the vows that they took. We wanted to share the story of Brian Amici, who was diagnosed with Alzheimer's disease in 2019. Shortly after his diagnosis, he was certain that he did not want to live through that pain and suffering of what the disease would bring, and that he was sure that he wanted to term his life. Brian was a very successful, brilliant architect. His wife, Amy Bloom, is a successful American writer. Before her husband's death, and now a psychotherapist as well, with the journey that she's been through, her goal in life is to help other people that have been through similar situations as her. Brian has strong feelings about people's rights and to agencies and autonomies. The arguments between them before the disease took a toll on his life always ended with Brian stating, "This is what I need to do." As the Alzheimer's progressed, Amy watched her husband forget the name of her grandchildren, get lost in the neighborhood. It was clear that the disease was taking its toll. As Brian was adamant and insistent, together they began researching the options for assisted suicide. Although the U.S. has 10 states with the right to die laws, Brian did not fit their strict criteria. Per Brian's request, Amy wrote a memoir that tells the story of their life journey. The title of the book is In Love. When you read the book, it sheds light to the different perspectives and it explains a part of life that we so often shy away from discussing. Through the book, we read their journey through the American law and what led them to Switzerland, and what criteria were met in order for him to be able to qualify for these programs. So although it's very controversial and people think, oh yes, they could just end their life in the state where they live, through the book we read that that's not the case, that there are still the laws that are in place have to have people qualify for the program. So this is a very interesting topic and it's a very interesting book. And again, this is a story that I wanted to share, Brian Amici and his wife Amy Bloom.
Hello, thank you, Teresa. I'm with Team E as well, and again, our topic is physician-assisted death. So, legal standout cases. All right, Crujan v. Director, Missouri Department of Health, Vaco v. Quill, Gonzalez v. Oregon. These are some of the cases that stood out and kind of brought this right to die movement to prominence. Reference material used. In our journey to understand this topic, we as a group decided to look into the book In Love by Amy Bloom, and it really gave us a good jumping off point. As Teresa said, Amy Bloom, really good book to help us get started. So as I've gone through the journey of learning this topic, dying like a dog has come up. So pet euthanasia is seen as an act of compassion and is deemed humane. Some people that are suffering from unbearable physical or mental pain would also like the same treatment for themselves, because it's seen as a peaceful way to transition to the next life or transition out of this world. So there's a saying, dying like a dog, and you might see a bumper sticker that says that, and that's what it's referring to. Physician-assisted death in America. Physician-assisted death is only allowed in a few states, as Teresa said, and guidelines can be very restrictive. So unlike Europe, where they don't have as many guidelines as ours, there are no exceptions for mental illness, dementia, or Alzheimer's. We just don't allow it at all over here. So that leaves people to seek care elsewhere. So seeking care outside the U.S. and in the form of veterinary euthanasia drugs. So because people feel like the system is failing them over here, they might cross the border to Mexico, meet with veterinarians, pharmacies, and get drugs, euthanasia drugs that way, or they may order them from China. If you try hard enough, China will pretty much send you anything. Reasons: people have some sort of physical, cognitive impairment later in life, right? So that's just life. So because of this, they could be a burden on loved ones. And people don't really want to burden loved ones. They want their loved ones to live their life because they know how short life is, and to go get a job and do things you want to do, not just care for me. People want to die with dignity. Dying with dignity means different things to some people, but to a lot of people, it means being able to wipe yourself, go to the bathroom, shower, cleanse yourself. Money. People don't want to be a drain on their family's finances most of the time. Autonomy. People have had decades and decades of being able to go get lunch, pick what they want to eat, go to a movie, drive yourself to appointments. Whenever you lose that autonomy, it's a difficult pill to swallow. Loss of mental capacities. Whenever you don't recognize your spouse, you don't recognize your kids, your friends, or other loved ones, that can be difficult, and some people might not want to live after the disease has progressed that far. Physician ethics. So doctors are trained to heal and give care. They aren't trained to end life. So whenever they're sitting there and they're looking at somebody, and their training is saying, let's save this person, let's do right by this person, let's heal, let's care. But this person saying, just terminate my life, that's a real ethical problem for a lot of physicians because of training. There is travel abroad for care. In those cases where you can't get care in America, there is travel allowed, but it is also a rough ethical dilemma for physicians. So travel abroad, you can set a specific date or time that you want to be that you want your life to end, right? So you can say on this date and time, or I've reached this progressive state in the disease, that I want my life to end. Then you go in, you'll speak to the physician, and he's speaking to a person that's smiling at him. Maybe the patient's having a good day. She knows her husband. She's saying, I'm having a good day. How's the week been? The week's been great. The weather's been great. It's very hard for them to say, I know you told me a year ago to end your life, but you're having such a good day. It really makes it hard for physicians to do this ethically. And that's only in Europe. So religious beliefs against and philosophical arguments for. So religious belief against would be God owns your life and only God can decide when your time will end. The philosophical argument for that, to claim only God can decide, means we can do nothing to prolong our lives. Means you can't do chemo, means you can't take blood pressure medication and stuff like that. If you're going to say this, then you should also be adhering to what you're saying. Another religious belief against would be living beings naturally try to preserve life. To go against this, nature is wrong in the eyes of God. Philosophical argument would be people have the right over their own lives, and the religious beliefs of others shouldn't interfere with my own decisions. So thoughts after the research. At the beginning of this topic, I was very pro let people decide, but after we've gone through this and learned a little bit more, I can see how it really is difficult ethically for some people to do. Thank you.
Thank you, Ronald. Now we are going to explore the legal aspects of physician-assisted suicide. To start, there is no consensus in the law to favor or disapprove of the practice. Today we're going to examine two cases that show just how divided the case law is when it comes to physician-assisted suicide. Oregon v. Gonzalez was formerly titled Ashcroft v. Oregon. It was a landmark case. The Oregon Death with Dignity Act, which was passed in 1994, which my counterparts mentioned earlier, gave physicians the authority to prescribe lethal doses of controlled substances to terminally ill patients. Attorney General John Ashcroft, in an effort to nullify the legislature, released an interpretive ruling in 2001 that declared physician-assisted suicide a violation of the Controlled Substances Act of 1970. For the point of this presentation, we're just going to call that CSA. Ashcroft threatened to revoke the medical licenses of physicians who took part in the practice. What's interesting about this case is that Ashcroft's argument did not focus on the ethical dilemma of physician-assisted suicide. Rather, he argued the conflict between one legislative act to another. As we go through these cases, you're going to see that pattern. The law does not consider ethics so much as the legislature. Keep that in mind as we move forward. Congress enacted the CSA as part of a comprehensive federal scheme to regulate and control certain drugs and other substances. A 1984 amendment to the Act allowed the Attorney General to prohibit medical practitioners' use of a controlled substance if that use was inconsistent with public interest. Ashcroft argued the use of controlled substances for physician-assisted suicide is not a legitimate medical purpose. The state of Oregon, in return, sued Ashcroft because of his interpretive ruling. The state asserted Ashcroft's motive was purely political under the Bush administration at the time. It was solely meant to punish physicians who practiced physician-assisted suicide. The state further asserted the administration improperly tried to use a federal drug law to prosecute Oregon doctors who prescribe overdoses. Justice Anthony Kennedy was one of the Supreme Court justices who ruled on the trial, stated Congress did not have this far-reaching intent to alter the federal-state balance. Justices on a 6-3 vote ruled in favor of upholding Oregon's position that the Oregon Death with Dignity Act does not violate the Controlled Substance Act of 1970, that physician-assisted suicide is a legitimate medical purpose. The ruling, in effect, was a reprimand to Ashcroft. Justice Kennedy said the authority claimed by the Attorney General is both beyond his expertise and incongruous with the statutory purposes and design. The ruling was later backed by a decision by the 9th U.S. Circuit Court of Appeals, which said Ashcroft's unilateral attempt to regulate general medical practices historically entrusted to state lawmakers interferes with the democratic debate about physician-assisted suicide. Ashcroft had brought the case to the Supreme Court on the day the White House announced his resignation in 2004. The Justice Department continued the case under the leadership of his successor, Attorney General Alberto Gonzales. Now we consider Myers v. Schneiderman, a case heard by the Supreme Court requesting legal relief and legalization of physician-assisted suicide. Here are plaintiffs, which were 3 terminally ill patients, Sarah Myers, Steve Goldenberg, Eric Seif, their physicians, in collaboration with the End of Life Choices New York, an advocacy group, took a more direct approach. They addressed a person's constitutional right to end their suffering. The plaintiffs sued the New York Attorney General seeking 2 forms of equitable relief. 1, a declaration that a professional who provides aid in dying to a mentally competent, terminally ill patient who has requested such assistance is not criminally liable under New York penal law. And 2, they wanted an injunction prohibiting prosecution of these professionals who aid mentally competent, terminally ill patients with the means and/or methods to end their lives. Each patient during the trial confirmed their mental competency before the court, making a request to seek aid in dying from their personal physicians through prescriptions to achieve a peaceful death. The professionals assert they have all treated terminally ill patients who have sought their help in ending their lives. The chief argument in Myers v. Schneiderman is that patients want to determine their fates when their respective diseases cause suffering that is too much for them to bear. The professionals assert that providing such help is both medically and ethically acceptable. The physicians asked the court to remove the risk of a second-degree murder charge, as provided by the New York Penal Code, to provide this service. Our plaintiffs argued that New York laws prohibiting physician-assisted suicide violates their 14th Amendment right to equal protection. Now, just to break it down, the 14th Amendment to the Constitution asserts all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states within they reside. No state shall make or enforce any law which shall abridge the privileges of immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of laws, nor to deny any person within its jurisdiction the equal protection of the laws. This is very important because the plaintiffs argued that physician-assisted suicide is a constitutional right, that ethically their right to die is protected by our Constitution. Of course, the state rejected this assertion, claiming the plaintiffs had failed to plead a justiciable claim. The penal law cannot be construed to prohibit physician-assisted suicide. The penal law does not violate the Equal Protection Clause of the New York State Constitution, and the penal law does not violate due process. When the case came before the District Court of Appeals, their ruling took a conservative approach. They did not rule on the ethical aspects of physician-assisted suicide. Rather, they stood firm that it was a matter of legislature. The Court of Appeals first addressed the argument against New York penal codes, asserting it applies to anyone and does not exclude physicians. The Court of Appeals also rejected our plaintiff's claims that it violates the Equal Protection Clause and due process because the court found no reason for a departure from a specific Supreme Court ruling, which was Vaco v. Quill, and it was a similar case. As for the due process clause, the court cited Washington v. Glucksberg, holding that there is not a fundamental liberty interest to committing suicide. The court noted that one's right to refuse medical treatment and to choose among medical treatments that has never been expanded to include a right to die or to get assistance from another to end one's life. Finding that the question only needed to be rationally related to a legitimate government interest, the court looked to several other cases, noting the historical trend that the state of New York itself has an interest in preventing suicide, maintaining a physician's role as healer, protecting vulnerable individuals, and preventing a slide towards euthanasia. It was a hard loss for supporters of physician-assisted suicide in New York. In closing, you have taken a journey with us to consider a very serious and dark subject. Does a person have an undisputed right to request help in their death? Does a physician who takes part in physician-assisted suicide violate their Hippocratic oath to do no harm? Is it fair that the state legislature can determine how you choose to die? Unfortunately, there are no straightforward answers. These questions walk the line between the personal and the political. Lawmakers themselves cannot agree or disagree, claiming it takes an act of legislature to make physician-assisted suicide a legal and ethical practice. What we can say is that some states and countries agree that it is ethical because it eases the suffering of terminally ill patients. Conservatives, however, disagree. As Ronald mentioned, they believe only God has that right. At the end of the day, physician-assisted suicide is an ethical dilemma that is as personal and as unique as the unfortunate individuals who have had to walk their path. So thank you very much for your time, and I hope you guys have a great day.